Hello, everyone. My name is Anthony Damesis, and I'm a professor here at the University of Ottawa in our Common Law faculty. I'm also our faculty's Moot Court Director, but more immediately, I'm your MC for the day for this wonderful event, our inaugural 2L Virtual Reality LeClair Moot. We pay respect to the Algonquin people, who are the traditional guardians of this land. We acknowledge their long-standing relationship with this territory, which remains unceded. We pay respect to all Indigenous people in this region from all nations across Canada who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. I'd like to now hand it over to our interim dean, Alain Roussy, who will offer some words of welcome. Over to you, Dean Roussy.
Hello, everyone, and welcome to Canada's first Moot in the Metaverse. Mooting has always been a strength here at the Faculty of Law Common Law section, but we are today bringing it to a new level. This is a first in the metaverse where participants are in multiple cities physically, but will be together virtually in the same courtroom. And we're not talking just about Zoom here. They are connected using virtual reality headsets. By the end of the event, I hope you will agree that this will showcase the innovation of our program, but also help in promoting a new understanding of how legal services can be delivered in our digital age. Last week, we had preliminary rounds, which got us 2 claimants and 2 respondents. So congratulations go out to everyone who participated, but obviously a special congratulations to the 4 fine students who will be battling out in front of us today. And by the way, all 4 of them are 2L students. We have 3 fantastic judges who will be judging today's event. First of all, Justice Ian Binney, retired justice from the Supreme Court of Canada, Justice Jody Lynn Wadilov from the Ontario Court of Justice and a graduate of our program. And last but not least, Mr. Ron LeClair, founder of LeClair and Associates, the law firm providing funding for the faculty's Metaverse project through to 2026. So thank you so much to the 3 judges, and a special thanks to LeClair and Associates for their very generous funding of this event today and in the years to come. Special thanks go out as well to the Engage XR team for making the virtual reality courtroom, our own tech fellows for their contribution and their vision for this project, our keynote speaker, MP Yasser Naqvi, and our MC, Professor Anthony Damesis. On that, I will leave it to Professor Damesis to take it over, and I wish you all the best of luck to the students. Best of luck in this event.
Thank you, Dean Roussy. Well, look, we all of us here at the law faculty are excited to showcase one of the many innovative approaches to advocacy that our students are immersing themselves in. And it's with the goal that they'll use these newfound skills in their future practice. Now, in a moment, you'll witness what, by most accounts, is the first time a moot court argument has taken place in virtual reality. Our brilliant students will argue before a distinguished panel made up of the Honorable Ian Binney, Justice Jody Lynn Wadilov, and Mr. Ron LeClair. And after the hearing, we'll hear from each of the panelists on their reflections from sitting in what we believe is their first virtual reality court. The case in dispute is based on Professor Eric Bergston's famous Moot problem used nearly 15 years ago. Professor Bergston, through his moot problems, has taught literally tens of thousands of students all over the globe how to become better advocates. I could not have thought of a better problem to use to launch our inaugural moot. Of course, we did have to tweak a little bit of that problem. We had to make it fit our Canadian domestic contract law principles. And instead of using international commercial arbitration as the means of dispute resolution, we had to domesticate it in the form of our own highest level appellate court. But the essence of this problem is Professor Bergston's problem, and I thought it was very important to make that clear. Now, briefly, this case is about a potential sale of ice wine that has gone wrong, at least in the buyer's eyes. The misinformation that was reported in the press about what chemical was used to sweeten the wine is at issue here. In the buyer's eyes, true or false, this misinformation rendered the wine inappropriate for its needs, which they argue was to purchase a wine to take the lead in a wine promotion. Now, there are also some technical issues for you law nerds out there related to, in particular, when a communication is deemed to arrive when one party uses an email. Arguing for the plaintiff claimants are Marina Bishara and Bahre Seyan Kavdar. And arguing for the defendant respondent team is Juliana Orlando Rohr and Natalie Oleksinki. Before we get to the hearing, we'd like to thank both Chris Madsen from Engage XR and Mr. Steve Lewis from Waking Dream XR for all their help and for rendering the recording that you're about to watch.
All right, we call the court to order. This is the case of Niagara Wine Cooperative and Ottawa Supermarkets. Are counsel ready to proceed? Yes, or indicating yes?
Yes, Your Justice.
Good. Could counsel for the plaintiff introduce themselves? You can do it from your place.
My name is Marina Bishara, counsel for the plaintiff, Niagara Wine Cooperative.
And your colleague is?
Hello, Your Justice. My name is Bahir Jehan Chavdar, and I'm the co-counsel for the claimants.
Very good. And for the defense?
Good morning, Your Justices. My name is Juliana Orlando Rohr, and this is my co-counsel, Natalie Olekchinsky.
Good morning.
We represent the respondents in this matter, supermarkets.
All right. Well, the bench is ready to proceed. Counsel for the plaintiff. Ms. Bishara, or do you go first?
Yes, Your Honor.
Okay, proceed when you're ready.
All right. Honorable Justices of the Foothill Hall Tribunal, today we present to you a case about ensuring that parties meet their contractual obligations. We have two submissions for your consideration. I will present you with the first one, and my co-counsel, Ms. Barye Sehar Javdar, will walk us through the second one. Our first submission is that a contract was formed between Niagara Wine Cooperative and Ottawa Supermarkets on June 19, 2020. Our second submission is that Green Hills 2019 was fit for the requirements of the contract. Regarding our first submission, we argue that the contract was formed on June 19 in the morning as soon as Ms. Amarone sent this letter of acceptance to Mr. Crew. And this is before receipt of any revocation from the respondents. We rely on three legal principles for this argument. The first is the postal acceptance rule. The second is that revocation must be communicated before acceptance. And the third is that are the provisions of Section 22(3)(b) of the Ontario Electronic Commerce Act. The logic here is that if we are to establish a timeline between when acceptance was communicated, when revocation was communicated, and which one came first, we would be able to determine the issue. I will proceed for the first principle about the postal acceptance rule. This is a tested and tried legal doctrine standing from the Court of England, 1879, from the case Household Fire and Grant. In this case, the court held that as soon as acceptance is sent by mail or is posted, then it's considered communicated. Therefore, when we look back at our facts, we see that Ms. Amarone used the service of ABC Courier and on June 19 in the morning, and this is when acceptance was communicated. Then we move on to the...
That case is 1879, and it's now 2022. And electronic transactions are authorized by statute, and the email of revocation was sent the day before on the 18th.
Yes, Justice Binney, I completely agree with you. The case is old, but we would like to bridge it into our modern day context through the provisions of Section 22(3)(b) of the Ontario Electronic Act. I just wanted to establish first that according to this rule, acceptance, which was sent by letter, would be communicated then. It was not by email.
Acceptance, but the revocation was sent by email. Why was it not proper to revoke a written offer with an electronic revocation before you sent the acceptance on the 19th?
So if we go to the Ontario Electronic Commerce Act, Section 22(3), this section is about the presumption of time of receipt. And the legislature provided us with this criteria about whether to determine if emails are a proper means of communication between parties or not. And when that is the case, when to consider information communicated, and in this case, the revocation. So we look at the language used, and it says that the addressee used or designated an information system for the delivery of information of the kind communicated. Of course, I'm rephrasing. I don't have access to the text, but this is the general essence of it. We argue that our client, who is the addressee in this case, did not use or did not designate emails as means of communicating this kind of information. We stand on the fact that first, Ms. Amarone did not provide her email address to Mr. Crew. Therefore, she did not use it. I'm hearing an echo. I'm not sure if you...
Like a squeaking noise. I think proceed. I think it's cleared up now.
Perfect. So Ms. Amarone did not provide the email address to Mr. Crew. Therefore, she was not expecting a communication. All the negotiations between both parties were done by letter. This is from determining the quantity of bottles that the respondents are paying, from determining the price that the respondents are agreeing to. All of these conditions were negotiated by letter. The only email that was sent from our client was sent by Ms. Kringle, who is an assistant to Ms. Amarone. Ms. Kringle, even in her email, she made mention of the letter. So she acknowledged receipt of the letter, and she acknowledged that upon Ms. Amarone's receipt, she will also proceed to take care of the letter. And this is why we were reliant on the postal acceptance rule, Your Honor. If we were to continue on and discuss Section 22, it gave us two options: whether the addressee designated and uses an email service for this type of communication, or they do not. Since our client falls under they did not designate or use email information system for this, then we would be looking at Section 22(3)(b. And here the legislature provided us with two conditions to determine the time of receipt of the document. And here we have The first requirement is that the addressee becomes aware of the communication. And the second is for the addressee to be able to retrieve it. And in our case, we know that the client had a service failure. They were not aware of the communication until they received it and were able to retrieve it on June 19 in the afternoon. And this is why we go back to this idea of timeline, that if acceptance was communicated June 19 in the morning and revocation was communicated in June 19 in the afternoon, then the contract had already been formed. And we base this on the principle in Byron and Van ten Hoven. To remind the court, this case is from the 1880s, and it's from, it was a year after household fire. And the court has had a buyer and a seller. The seller offered to buy, sorry, the buyer sent an offer to the seller, which the seller promptly agreed to as soon as received. In the interim, the buyer tried to revoke that letter, but the revocation was only communicated after the acceptance. And in this case, which was a year after the postal acceptance rule, the court had to determine whether they're establishing the equivalent of that, a postal revocation rule. And they rejected to do it. They argued and they applied that the revocation must be communicated before the acceptance. And this principle has also been applied in the common context. We see that the Court of Saskatchewan applied this principle most recently in Stadnik and Dash in 2008. So having said that, we've established that the contract was formed in the morning. If you have no further questions for me, I will allow my co-counsel Barrier to proceed with the second submission.
Okay, very well. Co-counsel? Barrier?
Thank you, Ms. Bashara. My name is Bahia Jehan Chavdar, and it is the claimant's position that the wine cooperative did not breach contract, as the Green Hill 2019 is fit for promotion as intended by Ottawa supermarkets. Now, there will be three parts in support of our second submission. First, it is our position that the respondent relied solely on their own expertise when ordering our product. And second, the contract between the parties should not be contingent on misleading commentary. And lastly, Green Hills 2019 is suitable for promotion. Now, justices of the tribunal, we know that the respondents wanted to use Green Hills as a lead in a promotion. However, we need to put this in perspective of their unique position. Now, Ottawa Supermarkets is not only the largest supermarkets operated in Ottawa, but they are also the largest wine retailer. Both parties of this claim attended the Lansdowne Fair, and I would like to stress that supermarkets sent a buying team. And as presented in our statement of claim, that very team showed a particular interest in our client's ice wine. Now, the respondents are a seasoned buyer, as they are the largest wine retailers of the region. They relied on their own expertise when they expressed interest in this wine. And in our client's correspondence, we do not come across any inquiries about any other wines. And within the correspondence between the parties, the language used in the exchanges actually revealed that it's not whether if they would order, it's just a matter of how many and when they would place the order. Our clients believe, and it's also our position that our clients believe that they did not put the respondents at risk when they did not disclose the use of diethylene glycol, since they actually believe that the usage was not so unusual that it warrants it as raising the point. As found by Professor Bergsten, the alcohol in the wine would induce toxic effects well before those resulting from the diethylene glycol. Now, we all know that 2019.
I'm not sure that that's the. I'm not sure. Hold on. I'm not sure that's the point. The fitness for the purpose relates to fitness for the use of this as a promotion. So it's the public acceptance. It's not whether the wine itself is toxic. So what the purchaser is saying is that you can't use this wine for promotion. Doesn't matter really whether it's misleading. The stuff that had appeared in the newspaper, it's simply not fit for the purpose.
And I understand, Justice Binney, but I would counter argue that with the position that if the conception is that any chemical that's used in non-consumable products is exclusively for that purpose only, then we would have a lot of readjusting to do. And if that suffices, I would like to continue on with my submissions.
Yes, continue.
So 2019 was a wet and cold season, and it's common knowledge within the wine industry that chaptalization is required in cool climate regions. Now, anophiles are usually cognizant of regional variations, and it's more so relevant for the professionals in the business of buying wines. When they have expectations of wine, they are aware of the history of the region and the weather conditions, especially in the abnormal periods. Now, both our client and the respondent recognize that the quality of the wine is in respect to its price bracket. And as mentioned in our expert report by Professor Bergston, it is normal to introduce a sweetening agent to bring it to a proper level for fermentation. Now, even which actually brings me to our second point. Now, after a client shares the executive summary done by Professor Bergston, Mr. Cruz states that, and I quote, "Even though there may be no health concerns associated with the quantities used in the Green Hills 2019, which I do not accept," unquote, is a disregard for the expert report that debunked the allegations against our client's product. Now, Mr. Cruz based his decision solely on the reports of the media, the base of which is actually on an article published in the words of our client, a sensation-seeking newspaper. Now, in 2015, British Columbia Supreme Court case, Golden Globe Pizza Inc. Versus Domino's Pizza of Canada, the plaintiffs applied for an injunction to prevent the defendant, Domino's Pizza, from terminating a franchising agreement. Now, the plaintiffs operated a store under Domino's Pizza's franchise, and a confrontation took place at the plaintiff's store involving former employees. And then the Canadian Broadcasting Corporation actually posted on its website a story that reported the allegations made by these former employees, which included that plaintiffs withheld pay and that they assaulted and threatened the employees. Now, this generated a widespread negative commentary about Domino's on social media. The defendants, Domino's Pizza, subsequently delivered a notice of termination. Now, the defendants actually relied on an agreement, on a contractual provision in their agreement, which actually stated that, which actually allowed termination based on a termination if the franchisee engages in a conduct that adversely impacts Domino's Pizza's reputation or goodwill, as conclusively determined by Domino's. So Justice Smith, in that instance, declared that if that the provision cannot be reasonably interpreted to give Domino's a right as sole and unreviewable trier of fact to say what the franchisee has or has not done. And further, he goes on to say that if the interpretation of that clause is given that way, it would give them a right to terminate an agreement on the basis of any evidence it chose to accept, even where the evidence was clearly unreliable or would be seen by an objective observer to be patently false. Now, even with a contractual provision...
Excuse me, isn't it for this court to determine whether the information published in Ottawa area newspapers is a sufficient reason to refuse the product? We're not talking
Yes,
here
it is.
about... all right, well, so go ahead. All right. So it's up to us to determine whether wine ordered for a special promotion into a market which has had this misinformation circulating about the poisonous quality of the wine was or was not an adequate excuse.
Yes, Your Honor, and we would like to ask the court to take into consideration the circumstances in which the respondent is actually refusing to take delivery of our client's product in this case.
Counsel,
Understood.
sorry, counsel, couldn't you just sell the wine to someone else?
Yes, yes, Justice LeClair. That would have been possible, but that would be accepting the revocation, which is not what we wanted to do in the first place.
but would that not help to mitigate any losses that you may feel you have?
Justice LeClair, I think our clients feel very wrong about the fact that this revocation is based on a misleading article, and that they would like to claim the damages resulting from this breach of contract.
Yeah.
And as for the aspect of promotability, I think we can actually take note of a PR problem that Labatt Breweries of Canada experienced in 2012. Now, in the Lawyers Weekly, Tony Wilson summarizes the circumstances, which I think is also befitting in our case as well. He says, if the only tool you have is a hammer, then everything will look like a nail. Sometimes you risk hammering your own thumb. Labatt Breweries actually threatened to take legal action against the Montreal Gazette for publishing a personal photo of a murder suspect holding their flagship beer. Now, although this picture was also available on the murder suspect's social media, they wanted the picture off the Gazette's site. Now, the story broke, and if Labatt had not treated the photograph as a nail in need of a hammer and had just left the matter alone, people wouldn't have associated the company with the murder suspect at all. So needless to say, in our situation, if they had taken delivery of the product as they had originally planned, it would not have been a commercial catastrophe as the respondents claim. So if there is a conception that, like I said, if there's a conception that chemicals used in non-consumable materials should be exclusively used for those purposes only, we would have a lot of readjusting to do. And this is still a wine that won an award at the fair, and it's still suitable for promotion. And justices, before I end,
Well, you see, I think an example going the other way would be when Perrier had a problem with their bottling machinery, and there was a tiny, virtually infinitesimal amount of oil that was leaking into the Perrier water, and there was absolutely no effect at all on the suitability of the drink. But the company took all of that water off the market because reputationally it couldn't afford to be associated with what was claimed wrongly to be a toxic problem. So I think the bench has to look at the problem from the perspective of the defendant as well as the Niagara winery.
And I totally agree with Justice Binney. And I do recognize that it did cause a bad reputation. But just because a region received a bad reputation doesn't mean that the products of that region is actually the quality of those products are diminished because of the bad reputation of the region.
No, but it may be unsuitable for a promotion.
I believe that there may be other ways to promote a product, and not everything should be dealt with in legal matters, and it's a problem of PR. And how they market, how they place the product on the market, it should be dependent on not just a wrong media rhetoric. It should be based on actual facts, and they should be able to support local businesses against misinformation like this.
Okay, we understand your position, I think.
Justices, before I end, I would like to leave you with one final thought. And if you find a breach based on bad publicity due to a misleading article, I believe that it could have the consequences of letting the media rhetoric be the only guiding factor of our decisions. Now, our client, an impacted party of a platform that purposely misguides its readers, suffered enough. Thank you.
Thank you very much, counsel. So is the defendant ready to proceed?
Yes, Your Honor. Your Justices, I will be addressing whether a contract was formed between wine cooperative and supermarkets, and Ms. Olekchinsky will be addressing if there was a contract formed, whether Green Hills 2019 met the requirements of such contract. It is a respectful submission that the purchase order from June 10th, 2020 never evolved into a binding agreement because the offer was withdrawn on June 18th before it could be accepted by Wine Cooperative on June 19th. My submissions will be divided into two parts. One, Wine Cooperative acted like there was a unilateral contract in place, and two, the email addresses were designated by Wine Cooperative. Hence, they should bear the risk of not receiving the revocation email. Firstly, Wine Cooperative acted like there was a unilateral contract in place and assumed performance was acceptance. Your Justices, I'd like this tribunal to keep in mind that this was the first time supermarkets and wine cooperatives were doing business together. This would have been a contract of $1.3 million. A principle of the law of contracts is that offerors can establish terms of a contract, including how they would like to receive the acceptance. Offerees must follow the terms of the offeror for an acceptance to be valid and binding. The letter attached to the contract, and that can be found on exhibit number 4, set out the terms for the contract to be accepted. The contract was to be signed and returned to Mr. Crew before June 21st, 2020. We know from Wine Cooperative's statement of claim that Mr. Kringle did not have the authority to accept the offer. But at the same time, in exhibit number 6, he responded that he had already sent the order to the order fulfillment department. Mr. Crew replies to the email and states, quote, "Please be sure to have Ms. Marone act on our purchase order immediately on her return," unquote. It is our interpretation that act in this case meant to sign and return the contract to Mr. Crew, not to just send the order to the order fulfillment department. Your Justices, it was inappropriate for Wine Cooperative to start performing the contract before having met the terms established by Mr. Crew. I would like to emphasize the Wine Cooperative is asking this tribunal to award damages for a breach of contract when the evidence shows that they actually opened themselves up for liability when they decided to act on an order before having a binding agreement.
But I don't think that's their position. Their position is that even accepting your view that the contract had to be accepted in writing according to the usual contract principles, that in fact they accepted before they had notice of your attempt to revoke it.
Yes, Your Justice, I'm going to address the revocation email before that, but the point that I wanted to make was that even though they claim that they accepted the offer on the 19th, on the 8th, right before, like when we sent the contract on the 10th, they acted like we already had a contract in place. And that's simply not true, because when Mr. Crew sent the exhibit number 4, he had those terms, and the negotiation was actually quite different than a contract. We had a contingency clause that wasn't discussed before. So Mr. Crew didn't even know whether Mr. Marone was going to accept it or not. So that presumption that we have a binding contract and let's just have the order through without even reading the contract is not acceptable to my client.
Counsel, did Mr. Crew, pardon me, counsel, did Mr. Crew tell the plaintiff not to take any steps until the signed document was sent back by Ms. Amarone?
It is our interpretation that when he said, please get Ms. Amarone to act on the purchase order, he meant that to sign the contract and send it back.
And not to take any steps prior to that?
He didn't specifically say don't take any. Yes, he didn't specifically say don't take any steps, but the way that he said it, like, please have Ms. Marone act on our purchase order, the interpretation that we have is that he asked Mr. Kringle to get Ms. Marone to read the contract and make sure that everything was all right before they proceeded with the contract.
Thank you.
Okay. Secondly, we addressed that the email addresses were designated by Wine Cooperative, and hence they should bear the risk of not receiving the revocation email. A general rule of the law of contracts is that an offer not under a seal can be revoked at any time before it is accepted. There are no requirements as to the formality of the revocation, as long as it is made clear to the offeree that the offer is revoked. In the email
it presupposes receipt of the revocation before the acceptance, does it not?
Yes,
and they say they didn't receive it.
Yes, the email was sent on the 18th.
And they say they didn't get it until after they'd sent the acceptance by courier.
Yes, but our position is that because they designated an email address, they should bear the risk of their server being down and them not receiving it. And we base that on the Electronic Commerce Act. So the Electronic Commerce Act is actually an adapted version of the United Nations Commission on International Trade Model Law on Electronic Commerce, also known as MLAC. The model law purpose is to enable and facilitate commerce conducted using electronic means by providing national legislators with a set of internationally acceptable rules aimed at removing legal obstacles and increasing legal predictability. Section 22(3) of the Ontario Electronic Commerce Act states that there is a presumption that once a party designates, an email is deemed received upon entering the system and becomes capable of being retrieved and processed by the addressee. I invite this tribunal.
Isn't the only email the one where you advised them that Ms. Amarone wouldn't be back until the 19th? Everything else seems to have been in letters.
Yeah, so so mostly all of the communications was by letter, but on exhibit number 4, when Mr. Crew actually sent the contract, the letter in the contract was also sent by email. We had a response from Mr. Kringle by email, and Mr. Crew replied again by email. So it would be quite unreasonable to think that, in our opinion, that Mr. Crew wasn't allowed to communicate with wine cooperatives through email. And because they also had their email addresses on the letter exchanges on the letterhead, I think like that also shows how they designated the email addresses. And to the point that Mr. Marone wasn't there, we believe that this was the easiest way to contact her, in Mr. Crew's opinion, and to be like as instantaneously as possible if the email actually went through. Because picking up the phone and calling, he wouldn't be able to reach her. And since she was in a business trip, I mean, like every time that I go on a business trip, I have my phone on me and I can check my emails. It was the assumption that she would have that with her. And even if she didn't, once she came back to the office before signing the contract, she would check her email before accepting the offer. I invite this tribunal to interpret Section 22(3)(8 along with the words of Lord Wilberforce in Brigham and Bond. No universal rule can cover all cases on instantaneous communication. They must be resolved by reference to the intentions of the parties, by sound business practice, and here's the important part, your justices. In some cases, by a judgment where the risk should lie. We submit that the email address was in fact designated by wine cooperative for the reasons that I mentioned before, and because of that, they should bear the risk of not receiving the revocation email. The same wording of Section 22(3)(8 can be found on Article 15 of the MLAC. A 2012 case in New Zealand, Patterson and Gothard, which also adopts the same wording from Section 22(3)(8, had similar facts, where the court had to decide whether a notice was served within the right time frame, since they had technical difficulties with the receiver's email server. They also had to decide whether the email was designated. In this case, the court decided that regardless of the server difficulties, it was sufficient that the email entered the receiver's server. And in respect to designation, the parties had a historical email correspondence similar to our clients, and that was enough to infer designation. We have a very similar case here. Sorry, Your Honor?
I think the problem with that is that the correspondence about when Ms. Amarone would return to the office and deal physically with the document that had been sent, suggests that the parties had not designated email as the preferred means of communication in terms of the formation of the contract.
Yes, Your Honor. I would agree with you, but since they already had the historical communication of emails, and that in our client's position, if he decided to send by courier, there was a chance that they could accept the contract and send it back, and then we would have a breach of contract. We would have a contract, actually. But this is different from our case. He acted prudently in a manner. He was like, okay, how can I send this and have wine cooperatives to receive this on the same day? And it is unreasonable to think that when you send an email, you're not going to have your email received because the server is down. If we interpret section 22.3 as a document is only deemed to be received when emails and other non-instantaneous communications are made aware for the receiver, we will always have an uncertainty about determining the time a contract was received. And in addition, since we need to interpret legislation in its entirety, there would be no reason why we would have section 22.3b, which just states that if the address is not designated, the document is deemed received when it becomes aware to the recipient. It would be unfair to place the risk on the revocation email not reaching Mr. Marone and Mr. Crew, since he did not know about wine cooperative server issue, and it was something that was not under his control. Deciding otherwise would be very similar to deciding that a text notice did not reach a person who duct taped their mailbox in an attempt to not receive a mail. Thank you, Justices. I'll proceed with my co-counsel.
Very well. Thank you very much.
Good morning, your justices. My name is Natalie Olekshinsky, and throughout my argument, I would like the tribunal to keep in mind that this is not just about a regular purchase of wine for our client to place on their shelves. Supermarkets is Ottawa's largest wine retailer with 75 locations across the city who was planning a special wine promotion in the fall. If the tribunal finds that a contract of sale had been concluded, in this case, Green Hills 2019, an ice wine containing antifreeze fluids, which was part of a wine scandal, would have been the face of our client's wine promotion in these 75 stores and possibly could have resulted in a commercial disaster. We submit that if this tribunal finds a binding contract, Wine Cooperative would have failed to deliver according to the terms of the agreement due to material breaches. I will start with a description of the purpose of the contract and follow with the 2 material breaches to this purpose. The purpose of this contract, again, was not to buy a wine. Instead, the purpose and intention of this contract was to buy an exceptionally fine wine that'll be the face of a wine promotion across 75 stores. Both parties were aware of this purpose as seen through the communications of Mr. Crew and Ms. Marone from May 2020 at the Wine Industry Trade Fair all the way to June 10th, as both parties emphasized that Green Hills 2019 is an exceptionally fine wine and again would be a great leader for Supermarket's promotion. For the record, Exhibits 1 to 3 show how this purpose of contract was communicated between the 2 parties. I could even quote for you from Ms. Marone in Exhibit 3, where she states, and I quote, "This is an exceptionally fine wine that will certainly satisfy all of your customers," end quote. This purpose is a condition to the contract on which all duties under the contract are meant to depend on. The notion that Green Hills 2019 is an exceptionally fine wine and will thus fit as the lead for the promotion is the heart of the contract. A material breach.
Aren't those 2 different things? There was the discussion about the purpose of the purchasing the wine. It's hard to say that a wine is top quality at $6 a bottle, but nothing was put in the contract that it be fit for the purpose of a presentation. What you were told is that people drinking it would enjoy it, and apparently that's true. So contractually, how can you say you were protected against something that went to the public image as opposed to the drinkability of the wine?
Just on the point of price, if we were to compare everything to the price of what a buyer buys it before then selling it to the next consumer, ideally, as a seller, you want kind of low cost, high profitability, right? So in this case, we are talking about an ice wine. Sure, it was $6, around $6 per bottle, but of course, as is known, usually ice wines are more expensive than their brothers and sisters of reds and whites, usually around $30 a bottle. And then in terms of the taste, going back kind of to how it didn't meet the purpose of being this fine wine, the articles kind of described and already put that public expectation of that there might be something wrong with it. The general customer would probably look onto Google and search antifreeze, or not antifreeze, or sweeteners, artificial sweeteners in wines, and they would get a variety of sources, which at that point might put a distaste in their mouth, knowing that such a product, such an ingredient rather, is no longer kind of what they would think to be even a fine wine for the purpose of a promotion. But we do think that this is a material breach because it strikes so deeply at this heart of the contract, like I stated, to be a fine wine for a promotion, a lead of a promotion. And at this point, it should render the agreement irreversibly broken because it defeats the making of the contract in the first place. We find there are two material breaches into the purpose and condition in this case. First, the quality of the wine is no longer exceptionally fine. And second, the tarnished reputation of Green Hills wine no longer allows the wine to serve its intended use as the leader of supermarkets promotion. Now, going into the first breach, like I noted earlier, Green Hills 2019 is an ice wine. Ice wines are more expensive. This is because it's a grueling wine to produce. The frozen grapes are picked by hand in sub-zero temperatures, usually in the dead of night, on a steep vineyard slope. Before the grapes have thawed, they are crushed whole using a press. Because the grapes are frozen, the juice that comes from them is concentrated and incredibly sweet, often rivaling with Coca-Cola when it comes to sugar content. Notice no mention of an artificial sweetener in this process. The use of a sweetener, especially one which can be potentially used as an antifreeze fluid, is not what makes an exceptionally fine wine. And even the head of the Canadian Vintners Association has stated that adding artificial sweetener to ice wine should disallow a wine grower to call their wine ice wine, but rather simply a general dessert wine.
So, Council,
Now,
just a question.
yes?
Pardon me, Council. Is your issue then with the use of sweetener at all? Or is your issue with the publicity that came as a result of the article that was published?
Both. We are looking at both that this sweetener was added and that as a result of the article, there was that tarnished reputation of Green Hills, which could have led into also supermarkets. My friend over here mentioned how just our party was sophisticated in this case, but in fact, both our parties are sophisticated. We've been in the wine industry for years. Sure, we didn't provide a list of what we classified to be an exceptionally fine wine, but reasonably, there are presumptions of ingredients you do not want in ice wine, like sweeteners, like grape juice concentrate, food coloring, or even maybe the shore waters of Lake Ontario after people swim in it. You can make a list of thousands of ingredients you do not want, of which, again, was presumed when making an agreement with the intent to promote a fine wine, what would not be in it. Professor Bergenstein's executive summary in Exhibit 13 provided there is an artificial sweetener in the Green Hills 2019, the diethanol glycol, which again, at its low quality, he states that it makes the wine safe to drink considering it's a antifreeze fluid. However, Professor Bergenstein indicates there is controversy around the exact amount of diethanol glycol that can be consumed safely. And to add on to that, he uses an American over a Canadian health and safe authority, which we question in making his claim. We also question, he stated that cane or beet sugar is often used to sweeten wines. So why did they not use the cane or beet sugar, a natural source, rather than this chemical? So accurate or not, with the level of diethanol glycol that's safe to consume, customers are not going to feel comfortable buying it. And as Justice Binney stated before, it's about also customer expectation, the public view. So this is a material breach because the purpose was to buy a wine to be the face of the promotion, and having a product causing customers to question the safety of it is not what our client looked for as the leader of this promotion. Now moving into the tarnished reputation.
Sorry, I'm going to interrupt. Go ahead, Justice Binney.
Well, I'm just going to a question here as to how far you can go with risking reputational damage. Supposing the newspaper had falsely claimed that this wine was made with child labor. It was a completely fanciful claim, but it caused a big stir in the Ottawa press. Is that reputational damage also sufficient to justify refusal? At what point
I believe
do we say
Yes.
It would be. Well, okay, that's
So I agree with you, Your Justice. However, those aren't the facts of our case. Here, we're not looking at child labor. We're looking at the use of artificial sweetener in a ice wine. Again, not just a dessert wine, an ice wine.
If I may interject as well, I do have a question on you doing your due diligence with prior to forming the contract, both sophisticated parties, extensive experience. Are these not the type of things that you would have clarified or confirmed prior to entering into a contract?
I agree with you, Your Justice, that yes, these are things that should have been confirmed. To the facts we have, we're unsure if any question was asked. But however, again, I would emphasize that these are presumptions of what would be in an iced wine, especially considering that Wine Cooperative is looking to enter the Ottawa market. It's a large market. We have a large population here in Ottawa. This was our first contract with Wine Cooperative. As well, we believed that what they were doing was great. Their wine quality was improving. So again, like overall, we entered into the contract with the assumption it's a fine company and it's a fine wine. However, this fine reputation was tarnished with the multiple newspapers in Ottawa released that exposed this wine scandal where antifreeze fluid was used to sweeten the wines. In the area the Green Hills 2019 grapes were grown. And just to emphasize on this, a reasonable person reading this article would at this point associate this antifreeze fluid with the fluid you place in your car engine during extremely cold temperatures. Being from Ottawa, this is something we're accustomed to. We've heard this term. We know this is something you put in a car. So at that moment, the reputation was tarnished, and a tarnished reputation causes people to have a worse opinion of them than they would have otherwise. So even if a consumer, let's say, was to do a simple Google search, I think I mentioned, of antifreeze to sweeten wine. You don't have to look up this diethanol glycol, as again, the article didn't mention the exact ingredient, but Google actually produces for you the notorious 1985 diethanol glycol wine scandal in Austria. Now imagine that you type this in 2020, and the scandal was in our beloved Ottawa, with a wine that was advertised as exceptionally fine under promotion and in supermarkets. Again, kind of to go back to that Austrian example. Oh, sorry, I'm not sure.
I think we may have a time problem here.
Oh, okay. Pardon. Yes. To conclude, again, we would like to go back to the fact that we did not, our client did not ask or did not sign on for a wine scandal with antifreeze ingredients. We contracted for a fine wine for a wine promotion. So the scandal, the use of antifreeze liquid, the tarnished reputation, and Green Hills 2019 not meeting the mark as a leader of a wine promotion shows a material breach where the purpose of this contract has been completely wiped out. We ask for this contract to be void and unenforceable and to place both parties back in the position as if the contract was never formed. So thank you, Justices. And again, if we have any extra time, we're open to any further questions.
Well, I think time has expired, but we've put our questions as council have made their submissions. So I think unless either of my colleagues has a question they wish to put.
Nothing
Hearing
further.
none, nothing further. Okay.
Nothing further. Thank you.
Okay. Well, thank you, council, for a very complete argument on a quite complex commercial problem. And we will take this case under reserve and deliver our decision later today. So thank you all, and the court is adjourned. Apparently I can somehow grip this, but I don't seem to be able to at the moment. All right, court is adjourned. Thank you very much.
Thank you.
Welcome back, and congratulations to our 4 advocates for their very able submissions on what is really a tricky set of facts. I certainly don't envy the judges who are deciding the case's outcome. We now have a very special treat for you. Our keynote speaker, the Member of Parliament, Yasser Naqvi, MP for Ottawa Centre, will offer what are always some sage words. allow me to offer a few highlights from Mr. Naqvi's impressive career. MP Naqvi is a lawyer and was the CEO of the Institute for Canadian Citizenship, Canada's leading voice on citizenship and inclusion. He served many roles in the provincial government, including as Attorney General of Ontario, Government House Leader, Minister of Community Safety and Correctional Services, and Minister of Labour. MP Naqvi currently serves as the Member of Parliament for Ottawa Centre and as Parliamentary Secretary to the President of the Queen's Privy Council for Canada and Minister of Emergency Preparedness. MP Naqvi is also a graduate of our law faculty. Thank you very much for spending time with us today, and welcome back to your faculty.
Well, thank you very much for that very kind introduction, and it's a great honor for me to be back. This room brings a lot of memories. Every time that I come back to Photo Hall, spend quite a bit of time in room 147. Justice Benny, it's good to see you. I hope you enjoyed your virtual reality version of yourself, probably the first time you've seen yourself in that particular mode. But I must say that I'm just absolutely blown away. This was definitely an experience that I wasn't expecting when I was coming over this afternoon, but it's just remarkable to see a moot take place in this particular format, which speaks to what the future could be. And I want to first start by congratulating everyone who's been involved in creating this particular way of doing a moot. I probably would think that this probably was the first ever in Canada, maybe in the world, to have a virtual reality moot to take place in this way. And so congratulations to everyone and to our Faculty of Law here at University of Ottawa. As I was sitting there observing this particular moot, it took me back to my time in law school here. And my participation in a moot, it was the Jessup Moot on international law that I was a part of. I think it was 1998. And the extent of technology that we used in that particular moot was to record ourselves do the arguments on a VHS tape player. I may still have that in my possession somewhere in a box in my basement. Because Professor Curry, who was our coach at that time, asked us to record ourselves and to view it at home to practice further our skill sets. And so that was the extent of the technology, which is pretty much obsolete today, and is to see how far we have come in creating now a virtual reality and be able to exercise and practice our skill sets, which will be useful in a court of law, in the advocacy and representation of clients is I think, quite telling as to what the future holds. But that leads me to, for me, to talk about a very important point, which is the utility of technology in our justice system. We in justice system are not known for speed. We're not known for a lot of creativity or innovation when it comes to how we practice our profession. In fact, many of our basic practices are the same as they were when my father was practicing law many years ago, a few decades ago now. And primarily, just before the pandemic, the only real innovation that we saw in our profession was perhaps use of fax machines and emails, because everything else remained the same, even serving documents, how we come before our courts, how we present our arguments. And very little innovation has been allowed within our system, which I think is to our own detriment. When I had the great honor of serving as the Attorney General of Ontario up till middle of 2018, one of the things that I was quite concerned about and focused on was to introduce digital means to ensure better access to justice. And in fact, back in 2017, we introduced a digital justice action plan, laid out a 5-year plan as to how we're going to bring more technology into our courtrooms so that we can help facilitate the delivery of justice in an appropriate, expedient manner. We had a big task ahead of us at that time because one of the most fundamental things that we identified in that action plan, and you'll laugh at this, was to just introduce Wi-Fi in all our courts across the province. I mean, this is the level of work we had to do in order to bring technology to the courtroom that many courts did not even have access to Wi-Fi available. You can imagine what other things we had to do. However, the good news, in my view, is, if one can think of the pandemic that we're living through as a good news, is that it did accelerate use of technology in the manner in which we provide for and operate our justice system. The manner in which our court system, our justices, lawyers involved, staff, the Ministry of the Attorney General, not only here in Ontario, but across the country, were able to just quickly, as the most famous term goes, pivot and use technologies like Zoom to be able to hold trials, was, to me, was quite encouraging that has happened. And I sincerely hope that it provides for a new baseline upon which we take technology at a different level, that we don't, once this pandemic's over, recur back to the way we used to do things in a nostalgic manner and undermine all the progress that we have made, because I think that is going to cause us some serious concerns. Let me make just 2 very quick points, and I will end. Point number 1 is technology is here. Technology continues to evolve, as we just saw with this particular mood, and one could just imagine from a complex evidentiary perspective how this type of a method could be so useful to holding trials in a digital format. But there is a lot of room still for us to use technology, and I often think of the devices that we carry now and the various apps that we use to live our daily lives. There is still tremendous opportunity and potential for us to use that sophistication when it comes to things that matter most to people in our justice system. And I'm not talking about complex legal cases like the one you were hearing, whether it's before the Ontario Court of Justice or the Superior Court of Justice, or is even at the appellate level. I'm talking about the bread and butter stuff, such as small claims court, such as landlord-tenant board, or the provincial offenses, where you're just fighting your parking ticket. There is a lot of opportunity for us to remove those matters out of a real courtroom to more of a digital space, so that we can make it more consumer friendly, so that we can make it more friendly to those who are litigants, who are involved in it. And I think technology has taken us to a point where we can do so in a manner that not only enhances access to justice, but also protects the rights of all individuals, all parties who are involved in those matters. That's where I hope, given the new baseline that we are operating on because of the pandemic, is what we should be focusing on, is use more sophisticated technology that we've got available, especially on matters that impacts people's daily lives. And I'll come to the last point as to why. As we know, in our democratic society, in our society that is based on rules, access to justice, real access to justice, is paramount. Making sure that people have access to a nonpartisan, completely independent judicial system that can serve people in a timely, expedient manner is absolutely essential. Given the nature of our justice system, and I can primarily speak for Ontario given I've spent time within this system, we're starting to lose that. If you look at today, the time lag when it comes to civil matters, when you're setting trials, right now in Ontario, as I understand, trial days are being set for 2024, 2025. That is not speedy justice. That is not access to justice. And what we're starting to see as a result, and what concerned me when I was the Attorney General and I was looking at some of the data that was being provided to me, is that those who are sophisticated parties in the system are opting out of our justice system and relying on more private arbitration and mediation processes. They are saying, look, I can't wait this long to get our commercial matter resolved or our civil dispute come to a conclusion. We will go and hire private arbitrators. No offense, Justice Binney, if you're involved in that practice now, but you probably see that, and get our matter resolved. And those, I call the have-nots in the system, rely on the traditional system of delivery of justice. Well, if that is not the definition of a two-tier justice system, then I don't know what it is. And just like we will not accept in Canada a two-tier healthcare system, where we have decided that our healthcare system has to be single-payer, universally accessible, publicly funded, well, there's no way we should be able to ever accept a justice system, which is cornerstone of our democracy, that is two tiers in nature. So from a public policy perspective, from a very fundamental issues perspective, I have a huge concern that by not adopting technology, by not making a system more fairer, by not ensuring access to justice, we are contributing to creation of a two-tier justice system that weakens our system, that creates a divide between haves and have-nots, and weakens our legal foundation in terms of precedent, because those who rely on arbitration, that case law is not part of our common law system. It's not part of our system, precedent system, because that's confidential and private in nature. So we are, in fact, depriving some really good jurisprudence from the common law development as well. So congratulations for coming up with this. I hope you take it to a whole different level and continue to be champions, as you are the lawyers of the next generation, to advocate for more use of technology from a perspective of to create a system that works for everyone and really is fair, fast, and in a meaningful way provides a system that provides access for justice for every citizen in our province here in Ontario, but for every citizen across the country. Thank you very much.
Well, thank you very much, MP Naqvi. And I think you'll be happy to know that here at the faculty, we do spend a lot of time thinking about how to reduce those barriers to access, this moot being just one. And next year, you'll see what we're doing with this moot as well. So thank you very much. We're now going to turn to the portion of the event where we hear from the very judges who sat on the finals bench. And we'll begin with someone who really needs no introduction, but I'm still going to do it. Anyone who has been involved in the law as a student, as an advocate, as a judge, knows our next speaker. The Honorable Ian Binney, I'm going to give you some of his highlights only, is one of Canada's most respected arbitrators and advocates. He served for nearly 14 years as a Justice of the Supreme Court of Canada between 1998 and 2011. And as someone who teaches contract law, I do want to thank you because your decisions are always clear and even entertaining to read. So they're always easy to assign as readings. Before his time on the Supreme Court, he served as Canada's Associate Deputy Minister Justice from 1982 to 1986. He was later appointed Special Parliamentary Counsel to the Joint Committee of the Senate and the House of Commons on the Meech Lake Accord. So you constitutional folk should also take note. Today, Justice Spinney is a civil litigator at Lenzler Slate in Toronto and an arbitrator with Arbitration Place. And I can tell you as someone who's also has a foot in the world of international arbitration, he continues to teach us as he writes, thinks, and speaks about this area of the law. Thank you very much for spending a Saturday with us, and I'll turn it over to you now.
Okay, well, thank you very much for that introduction. It is, in fact, a huge pleasure to spend this particular Saturday at the law school. I am quite frankly stunned at the level of technology on display. As someone who began to practice law before there were even photocopiers, and was amazed when we first had the wet copy machines with contracts spread around the office drying in the atmosphere. And of course, typewriters, no photocopiers. In Toronto, when you wanted to deliver a document, we had a huge advance of a business that started up a document exchange, so you trundled your boxes of paper back and forth. So really to emerge from that, and now some 56 years later, to be sitting in a virtual courtroom was quite astonishing. And I mean, not only is it an honor to have participated in what was called the first moot in the metaverse. I mean, it's a terrific expression. I've never been in the metaverse before, and I never expected to be. And it sounds a little Star Trek for somebody of my age. But as with moots that are not in the metaverse, the mooting was excellent. And it's the content of the moot that fundamentally takes first place. And I congratulate again each of the four mooters who did a terrific job. But on the technical side, it is quite extraordinary what we have all just witnessed. The way in which the figures appear, the way the camera swirls around the courtroom, focuses on different people at different stages. The level of control was extraordinary. And in fact, when the session ended and the helmet was removed, I was temporarily rather stunned to find myself out of the metaverse and back in the setting of the Ian Scott courtroom. The metaverse has a lot of advantages. You can order up your own avatar if you'd like to be a bit taller, thinner, more glamorous. The avatar can be produced to order. The courtroom can be controlled to a far greater extent than an actual courtroom, which is usually a good deal more chaotic than the metaverse courtroom. The mooters function within 10-minute time limits, which I found astonishing. particularly with a case of the complexity of the one we had. In appellate courts now, the time limit is disciplined by a red light that comes on. Some people argue that it should be possible just to cut off the microphone to the lawyer in mid-speech. But the virtual courtroom gives the possibility of actually making the lawyer disappear altogether, which is a whole new step in judicial control of what goes on in the courtroom. I think there are some disadvantages, well recognized. It was very odd to be sitting there having a document referred to and not be able to look at the document to see whether it had been accurately quoted or whether there was something else in that document that threw a different light on what was being said. It was awkward not being able to make notes, because as you moved your arms, your avatar sort of was shown as wildly gesticulating, and you had no opportunity to view the notes in any event. So there's a lot of work to be done in order to make it serve the purpose of a real dispute resolution mechanism. But the progress to date is quite astonishing. And the people who have brought it to this level and who are carrying it further deserve tremendous credit for taking an advanced technology and attempting to tailor it to the needs of dispute resolution, whether arbitration or court work. So we're all we are all in their debt. So with congratulations to the mooters, congratulations to the technical people. I'm very proud to have been part of the first moot in the metaverse. Thank you.
And thank you, Justice Binney. Really is a treat for students, second-year law students, to have a moot, the former Supreme Court Justice. So thank you very much. We'll now hear from our second judge, Justice Wadilov. Now, the Honorable Justice Jody Lynn Wadilov is an Anishinaabe and Lenape from the Munsee Delaware Nation in southwestern Ontario. In 1999, she received her Bachelor of Arts degree from the University of Western Ontario. In 2000, she received her Master's of Arts degree in International Criminology and Law from the University of Sheffield in England. Also in the year 2000, Maclean's magazine named her as one of Canada's top 100 under 30 to watch in the new millennium. In 2003, she received her Bachelor's of Law from right here, University of Ottawa. She was called to the Ontario Bar a year later and the Alberta Bar 2 years after that. In 2004, and during her articles, she was elected as the youngest counselor for her First Nation community, the Munsee Delaware Nation. Also in 2004, she was appointed Assistant Commission Counsel for the Ipperwash Inquiry. The Commission's mandate was to inquire and report on events surrounding the death of Dudley George, who was shot in 1995 during a protest by First Nations at Ipperwash Provincial Park. In 2007, she joined the Ministry of the Attorney General for Ontario. She later joined the Ministry of Community Safety and Correctional Services. And in 2015, she was seconded to the Indigenous Justice Division, where she served as Executive Advisor and Legal Counsel to the Assistant Deputy Attorney General. In 2016, she served as Senior Legal Counsel to the Independent Reviewer, the Honorable Justice Tulloch, at the Independent Police Oversight Review, and in 2017 at the Independent Street Checks Review. In 2016, she was selected to participate in the 2017 Governor General's Canadian Leadership Conference, and later at the Governor General's first Indigenous Leadership Summit. Justice Wadilov has been given 9 Eagle Feathers and 2 Eagle Fans. The Eagle Feather is the highest honor given in the First Nations culture. In 2018, Justice Uottawa was appointed to the Ontario Court of Justice, and we thank her for taking time out of her day today to serve on our grand finals bench.
Sorry, Justice Uottawa, you're muted.
I first want to thank the University of Ottawa Faculty of Law, Professor Anthony Damsis and Mr. Rotesh Kotak for what has been an extremely successful and unique mooting experience. Mr. Kotak in particular gave a significant amount of his time and energy into making this virtual reality moot happen today. So thank you to Rotesh and the many volunteers on your team who helped make this happen. If a picture is said to be worth 1,000 words, then an immersive virtual reality courtroom experience should be worth at least 100,000. Virtual reality is commonly used for entertainment or education experiences. After today's experience, I think the possibility of using virtual reality in the courtroom is exciting and promising. Instead of using traditional visual aids such as photographs and PowerPoint, it may soon be possible for members of the court to be putting on headsets and to become immersed into a 3D court proceeding that could also later offer a 3D visualization of a crime or accident scene. The ability to see a 3D representation of both the court proceeding with the actions at issue could offer a better understanding and an interpretation of the information being presented. From an accessibility perspective, if the technology is available and affordable to citizens, it could be used to put persons who are physically separated into the same room, including the courtroom. This could change the way justice participants meet and prepare for court, as well as attending and participating in actual courtroom proceedings. This would be an exciting prospect for those living in rural and remote communities and who do not have close or frequent access to a courthouse. Finally, I believe that should the technology be available, reliable, and accessible, its use in the courtroom is something to embrace. Based on my experience presiding in the virtual reality courtroom today, I look forward to it. Thank you.
Thank you, Justice Uottawa. We'll now hear from the third member of our grand final bench, Mr. Ron LeClair. Mr. LeClair is a principal lawyer at LeClair & Associates, specializing exclusively in management-side labor and employment law. He assists various private and public sector clients with a full range of workplace legal issues. He's a highly sought-after speaker and lecturer on many labor and employment law topics. LeClair & Associates has kindly sponsored this moot through to 2026, and we are sincerely grateful. We'll be saying a little bit more about that towards the end.
Thank you very much, Professor Damsis, and thank you everyone that is here today participating in this inaugural event. I feel like the mere fact that the University of Ottawa was prepared to put this event on says a lot. It demonstrates a passion and a commitment among the faculty and staff to advancements in our legal profession, our legal systems. And I find it very encouraging and frankly inspiring to know that up-and-coming lawyers are embracing new technology and finding better ways to serve our public and to provide better access to justice. As we all know, law really should reflect society, and I believe we have to be vigilant in anticipating that and preparing for what's to come in society. And it's for that reason that initiatives such as this are so important, because it provides us with an opportunity to explore what's possible as we look at the intersection between law, society, and technology. I wanted to give a special thanks to a few individuals, certainly the Honorable Justice Binney. It was a pleasure meeting you today, sir. Thank you for being here. Justice Uottawa, pleasure meeting you as well. Thank you for your attendance and participation on the bench. Professor Damasis, thank you very much for the opportunity. And I also want to recognize Ritesh Kotak, who I think initially had this tremendous vision, and with the very able assistance and collaboration with the uOttawa Faculty of Law Tech Fellows, was able to pull all this together. So it was a tremendous effort by a lot of people, and I commend all of you. So on to today's moot. Just one quick announcement I wanted to make, which is, in addition to the cash prizes for the two teams, we also wish to let the 4 individual mooters from today know that they will be permitted to, or able to keep their headsets. So they're yours to keep, enjoy them, keep using them, keep learning from them, and keep exploring ways that they can benefit all of us in society. Today was certainly an amazing experience in advocacy. We were all those of us on the bench were very impressed with the ability of the 4 mooters to break down what was really a very complex legal problem and come up with meaningful legal solutions. They managed to untangle a lot of facts in a very short period of time. So I'd like to recognize the 4 mooters by name. For the claimants, there was Marina Bishara, Bahuriye Kayan Kabdar, and for the respondents, we had Juliana Orlando Rohr and Natalie Oleksinski. So as we went through our deliberations as a panel, we obviously had a very difficult job to do. It just struck us that based on the facts as we went into the moot, that the claimants probably had the tougher case to make. And that certainly informed our decision making and our deliberations. It seemed to us that through their vigorous advocacy today, they were able to level the playing field. And while it's a very difficult decision for us to make, given the high quality of all 4 mooters, the panel did ultimately decide in favor of the claimants. So the victors in today's moot, today's first ever moot in the metaverse, were Marina Bishara and Barahe Kehan Kabdar. Congratulations to all of you. Thank you.
Thank you very much, Mr. LeClair. Now, it's true, this event could not have happened with countless members of our faculty, community, and friends, and I would like to just name them here. First, our outstanding grand final judges. I'm not sure when you're going to be watching this, but you should know that this is a Saturday afternoon. We started in the morning, and it's getting to mid-afternoon already. These very busy individuals volunteered their time, so we are grateful to them. MP Yasser Naqvi, for sharing time again with us on a Saturday, and for sharing your thoughts about the vision that you see for access to justice and the future of our law profession. Ritesh Kotak. I'm going to name the whole team from these tech fellows and then tell you a little story about Ritesh. Ritesh Kotak, Ayushi Dave, Melissa Dupree-Crane, Adam Levesque, Ali Agamu, Mona Shadid, Aaron Heidel, Ryan Mosoff, Olivia Hugh, and the entire tech fellows. This really could not have been put on without them. I think it was back in September or October, I received an email from Ritesh, and a little bit about why this moot even got started was last year, owing to the pandemic, our first-year law students missed out on the opportunity to participate in our annual first-year moot. So I was thinking, how can we get these now second-year law students to get that experience back? And so I was thinking about, well, why don't we put on a 2L moot? And then this email from Ritesh enters my inbox. And he says, would you be interested in doing something a little bit different this year? I said, sure, why not? And he used some tech jargon that I wasn't really following, but it sounded good enough in that email. So I said, sure, let's meet. Well, I can tell you from that moment forward, I had very little to do. All I had to do was put together this problem, and Ritesh and his team took over everything. And I'll admit that 2 weeks ago in one of our faculty meetings, I put forward a motion that would it be possible to not allow our current tech fellows to graduate this year so that they could stay with us for another year. And you'll be happy to hear Ritesh and team, the motion was not passed, but it was close. So be careful. They really are a backbone to our faculty these days as we've moved not merely into the metaverse, but into this online platform. So thank you very much. This also couldn't have been done without our marketing team, Véronique Larose, Augustin Denis, and our IT and communications manager, Eric Proux. All the judges from our general rounds, which took place last week, they were all former Mooters of ours. And I was greatly touched to know that it took me one email and maybe seconds later to fill up all the judging spots. Our Ottawa Mooting alumni is really strong, and we greatly appreciate everything that you've done and will continue to do, because you'll get an email from me next year. Also, Engage XR and Waking Dream XR. This platform wouldn't exist without them, so thank you. There are far too many members of our faculty to thank, but I'd like to just point out a few, including Professor Stephen Bindman, Dean Roussy, Professor Adam Dodek, Professor Stephen Blair, Professor David Wiseman, who is our current Vice Dean, and Professor Craig Forces. There's so much support in this faculty, which of course makes working here such a great time. And of course, to our sponsor, LeClair and Associates, Ron LeClair has been involved from the start. And he's not just a passive sponsor. He really has been there on those Friday night meetings, I think maybe even a Saturday meeting, always enthusiastic and always supportive. It's really been a pleasure to work with you, Ron. You're a gentleman. And on behalf of our faculty, we are looking forward to this relationship. And thank you so much, because this wouldn't have happened without your generous support. So that wraps it up from here in Ottawa, and I suppose the metaverse. Thank you for taking time to share this special event with us, and keep your eyes and ears open for next year's 2L LeClair Moot, because we've already started to work on next year's problem, and I assure you, it's going to blow your socks off. So thank you, everybody. We look forward to seeing you next year.